I'm Nate Eaton, and this is True Crime Rocket Science.
Hello, and welcome to True Crime Rocket Science, the most authentic voice in true crime. Central to the defense's argument calling for a brand new trial is an interview juror number 8 gave to East Idaho News. That was just a few days ago. Remember, the juror indicated that the instructions they were given were confusing. That's what he said during that interview. And so what this leads us to ask is, firstly, will there be a new trial? And number 2, should there be a new trial? Before we get to that, if you haven't subscribed to the channel, please do. If you're enjoying this episode, please like, share, leave a comment. If you're really enjoying it, you can hit the thanks button, and let's get started. Now, according to the Idaho Statesman, in the interview, Hernandez said that the police in Arizona had, quote, some significant red flags, end quote, and that they'd followed up on some things. Had they followed up on some things, maybe there wouldn't have been a trial in Idaho. And I think he means there would have been a trial in Arizona, right, instead. And then Nate Eaton from East Idaho News then sort of responded saying, are you talking about after Charles Vela was shot? And the juror then said, yes, well, before and after. Nate then said, that the juror was right, and he referred to body camera footage of Charles Vela in 2019, 7 months before he was killed, where he said to Gilbert Police, to the Gilbert PD, that Lori has, quote, lost her reality, unquote. And also Charles said that he was worried about Tylee and JJ's safety. And so the defense sort of seized on this aspect. They said that Hernandez's comment about Arizona PD wasn't part of the evidence presented during the trial. And that Hernandez and Eaton referring to it in the interview, is kind of a problem. Now, the fact is that the juror doesn't specifically mention the footage, the body cam footage. I'm talking about the dealing with Charles saying that she's lost her reality. But he slightly shakes his head when Nate mentions it. And so it's really in reference to this. If you think about it, it's kind of reaching, isn't it? And so the motion reads, quote, we can only conclude that the juror relied on information not presented in court to reach his conclusion that Arizona dropped the ball and should have done more even before Charles Vela was shot and killed by Alex Cox, end quote. Can you see what they're trying to sort of argue is that the juror was sort of contaminated, that he knew things because he'd been watching the case, or he knew things about the case, and when he was asked about it, he didn't say that he did know that, right? Does that make sense? So on a tiny detail like a shake of a head, on these delicate nuances, legal fortunes can, and sometimes do, turn. But, as we saw in the Scott Peterson case, one often needs to see serious and significant failings by a court to warrant a mistrial or retrial. And so in the Scott Peterson case, you saw what happened with the juror didn't really affect the outcome, whereas in the Adnan Syed case, it kind of did, but then, I don't know, I guess we'll still have to see. It should be noted that what Lori's asking for doesn't appear to be an appeal. Since the prosecution presented significant amounts of evidence, this is the other side of the story. Since the prosecution presented significant amounts of evidence from the Charles Vela murder, including blurred out screen grabs of Charles lying on the floor, I don't think it's much of a stretch to infer that there was body cam, right? But, I mean, I guess what they are referring to is the body cam much earlier. Again, it kind of feels like they are reaching, doesn't it? Going back to the article in the Idaho Statesman, quote, Hernandez, during the interview, also said that it was clear to the jurors that testimony and evidence related to Arizona were only for demonstrative purposes. But in the motion, the defense pointed out that any evidence regarding Arizona wasn't admitted for demonstrative purposes, but instead was admitted to show that any alleged crimes went toward the prosecution's ability to prove just the following: motive, opportunity or intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. In other words, it's not really meant to show character. So do you see, once again, the details matter. Going back to the motion, it cited two additional reasons why Laurie's conviction should be vacated. They said that the motion had misdirected the jury about the law in regard to the 3 conspiracy charges. Now, I don't think you can kind of get around the fact that this is quite confusing. Even if you explain it very clearly, it nevertheless is quite confusing given the case that we're dealing with. So in the indictment, prosecutors said that either Chad and Laurie and Alex Cox and other co-conspirators, both known and unknown, conspired to kill the children and Tammy Daybell. And so they're kind of saying that, they're kind of leaving the door open, saying it could be this person and that one, it could be this person, that person, and that person, it could be this person, that person, and that person, and on and on and on, right? They're not kind of limiting themselves to say it was definitely just 2, or definitely just 3, or definitely just 4, right? And the defense argument is that during the trial, the government alleged that the conspiracy was only between 2 people, meaning either between just Chad and Laurie, or between Laurie and her brother, or between Chad and Alex Cox, right? And then this is their point: to have the government and the court permit a conspiracy of just 2 people instead of 5 was prejudicial and unlawful. Now, that argument from the defense I find kind of weird. I understand that being forced to prove a conspiracy between more than 2 people is pretty difficult to do. But as far as I'm concerned, that's setting the bar far too high to say we need to make it, 5 people or whatever. But what they're actually arguing for is the opposite, is that it should have not been 5, it should have been just 2 or something like that. So I even find their argument a bit strange and not necessarily logical, because I'm sure had they done it the other way, they would have argued it the other way. So in sum, while there is some merit to these arguments, it should also be noted that the defense failed to field any case whatsoever. Laurie failed to testify at all on her own behalf. And the state's case, in spite of any potential defects, was pretty ironclad. So you might cry, I was going to say cry wolf, but you might cry foul about this, that, and the other thing, but your own lack of a case is also going to kind of come back to bite you. Just say, really? This is really bothering you? Well, what about your case? What case did you offer? So to answer those questions posed earlier, no, I don't think there should be a new trial. And I'm speaking from a strictly legal perspective in terms of any legal imperatives. And I don't think there will be a new trial for Laurie. But if there are any lessons to learn from this, I think it's that jurors need to be careful talking to the press and reporters who care about the cases that they're reporting about. They don't want to shoot themselves in the foot. Maybe you want to wait until that sort of deadline period of 2 weeks has passed before publishing these sort of interviews. And so if they do give interviews, preferably do so later rather than sooner. And so I think we've got to come back to Laurie's reaction when the verdict was being read. What do you think she was actually thinking? What do you think all murderers are thinking when verdicts are read? Well, isn't it the following? Isn't there a loophole somewhere here? Well, I don't think there is, but even if there was, Laurie has always had a huge amount of evidence weighing against her. Thank you for listening, and I'll see you guys next time.